Hi everyone, this is a presentation by the Empower Debate Resource Creation Team, and today we're going to be talking about the 2024-25 policy topic. This year's topic is about intellectual property rights and whether or not they should be strengthened. An overview of today's presentation, we're going to be discussing this in 4 parts. So first, we're going to discuss the resolution, so some of the key words that appear in the resolution or the topic. Then we're going to talk about the para-affirmative, going over strategy when you're aff, defending it, and also explaining some of the concepts presented. Then we're going to talk about negative arguments. Some of this will apply to the whole topic, but we're mostly going to focus on the arguments that are applicable to the para-aff, since that's what we've been discussing in the other part. Then we're going to talk about some concluding thoughts. So first, the resolution. The United States federal government should significantly strengthen its protection of domestic intellectual property rights in copyrights, patents, and/or trademarks. We're going to dive into what all of these mean, especially the more obscure ones. So first, intellectual property / intellectual property rights. Intellectual property is intangible ideas or creations. So when you think of an idea, it's technically your intellectual property, given that someone else doesn't possess the same idea. That does not mean it's automatically protected by law. Other people can replicate it. If other people think of the same idea, it's not necessarily just your intellectual property anymore, because someone else also possesses it. But the reason that intellectual property becomes exclusive, or it becomes important, is because of intellectual property rights. So these are the legal rights that are actually granted to the person who has intellectual property. So an inventor, author, or a company. Usually this is an individual, but it can also be a firm or a company, especially when we're talking about technology and innovation. Those tend to be industries or companies within those industries who are trying to, make a profit or come up with something inventive. So the concept of an intellectual property right basically guarantees exclusivity or exclusive use for the intellectual property. So if an author or an inventor or a company has an intellectual property right for some kind of intellectual property, whatever idea, whatever creation, then no one else besides the person who has the right is able to recreate that. So, for example, if I have a copyright on Harry Potter, say I'm J.K. Rowling, then no one else can recreate the Harry Potter movies, cannot write the books and sell them without my permission. Since I have the intellectual property right, they are not able to do that, which the concept of infringement just refers to people who try to essentially recreate the things that you have an intellectual property right over. So an IPR excludes and prevents infringement. There are 3 main parts of IP. There is another extraneous part that's not technically an official part of the concept, but the main ones that are covered in the resolution are copyrights, patents, and trademarks. I put in a card just as a brief overview of what each of these mean, but we're going to go ahead and dive right into the specifics, so you don't have to worry too much about this one. So first, copyrights. This is the first topic area that's presented in the resolution, and the purpose of a copyright is to protect the works of authors. This is not necessarily the same thing as an inventor, which also comes up in intellectual property rights, but is a slightly different thing. Usually when we think about inventors, we think about technology and innovation, so new inventions that are, take the form of machinery or are meant to make something more effective. When we're talking about authors or authorship, we're usually referring to literary works, artistic works, things like books, music, paintings, movies, anything like that, which is slightly different from the stuff that inventors deal with. So the duration of a copyright is 70 years after the death of the author. So once the copyright is granted, it lasts until the end of the author's lifetime, and then an additional 70 years beyond that. So usually that'll be, it'll end up being 100 years or more. The main requirement for a copyright, or for being eligible for a copyright, is that the thing that is being copyrighted needs to be tangible and fixed. So it needs to be recorded in some way. If it's a book, probably needs to be written down on paper. If it's a movie, obviously recorded, a painting, sure, somewhat self-explanatory, but the point is, all of these things are somehow recorded through a permanent medium where it can be easily observed and understood by others. A patent deals with more of the invention things that we talked about in reference to copyrights and artistic works. So patents protect discoveries and inventions, which usually deals more with new technology and sort of the innovation that a lot of the topic will likely deal with. There are some guidelines for what can be patented, which will also be discussed in the analysis of the para-affirmative, but the main criteria is that the patent must be novel, so it needs to be a new idea, something that you have come up with, something that's unique and not a recreation of something that already exists. It needs to be non-obvious, so it can't just be putting A and B thing together. It needs to be something that takes a little bit of critical thinking, takes a little bit of entrepreneurship even, and then it also needs to be not abstract. This one is a little vague and causes the most confusion, especially when we talk about the courts, but essentially it means you can't patent things like laws of nature or mathematical formulas or business strategies, because that's far too broad and it would likely lead to a lot of problems, since if one person holds a monopoly on, a mathematical formula and it can't be used by other people, that could pose a problem to a lot of people, which is the main reason that this criteria exists. The application for a patent, once it's filed, it goes to the USPTO, who deals with a lot of those applications, as well as just makes sure that all of these applications and the patents, once granted, are dealt with and managed. The duration of a patent tends to be 20 years. There can be some exceptions, for example, pharmaceutical companies, since it takes a lot of time for them to develop new innovations. They sometimes get an extension from the government. There are some regulations surrounding that, but generally most patents are going to last for 20 years. The last topic area presented is trademarks. So this one is mainly used in references to brands. So this is whatever is used to identify and distinguish the source of a good that is being produced and sold. So when we think about companies like Nike or Google, they obviously have distinctive logos, symbols, etc. that they use to promote their products, but also to signal that a thing is theirs. That's the purpose of a trademark. The Nike logo is protected by a trademark, and it allows the brand to distinguish themselves and basically put their mark on the products they're selling, so that consumers and customers know what they're getting and where they're getting it from. This protects a brand's identity rather than the actual things they create, so it's not a protection of the good that is being sold, but rather a protection of the brand and how they are able to market said good. The last thing, and arguably the most important one for the resolution, strengthening protection of intellectual property rights. So this one's the most ambiguous. This tends to be the case for all the mechanisms in the resolution, which is really just the action that any affirmative has to take. It's the main mechanism and probably the one that a lot of our research will be centering around for the season, because there's a lot of ambiguity and it's also very complicated. There's not a cut and dry definition, and a lot of scholars have written about this. It's a very specific term that is used in the intellectual property rights context, and you won't really find this term in other places. It's very specific to the topic. So the main interpretation, and the one I believe will be most common based on what happened at debate camp and what's happened so far this season, is Mandela 18. I've put in a copy of the card for everyone to reference if needed. I believe this can easily be found in the novice packet. If not, it's certainly accessible online in some format. But essentially, the Mandela card says that when an action strengthens IP, it must help the rights holder. So some examples that the Mandela card identifies as helping the rights holder is broadening the scope of IP, making it easier to acquire IP rights, and make it easier to prove, or strengthening remedies for infringement. These are all examples of topical affirmatives. There is additional ambiguity about what falls into each of these categories, but this is the broad kind of definition and expectation about what you should believe affirmatives will try to focus their research around this season.
Hey, this is Layton, and I will be going over the Patent-Aff from the START packet, which is Plan. The United States federal government should strengthen its protection of patents by passing the Patent Eligibility Restoration Act. So what is PARA? PARA is a piece of legislation with the goal of creating clarity and certainty in the patent system. This would overturn 4 decisions called the Alice-Mayo decisions, which created exemptions which created massive amounts of uncertainty in the patent legal system. So before Alice-Mayo decisions were created, there was already 4 requirements to have a patent. It must be new, which means like it can't have already been created. It must be non-obvious, which means to have an inventive step, aka you did something that like wasn't super foreseeable. It must be disclosed. You have to have a tangible way of showing how you made the thing, and it must be something called subject matter eligible. Subject matter eligibility is what PARA changes. The Alice-Mayo decisions created certain things in subject matters that may or may not be eligible, and PARA would clarify what is and what is not eligible by getting rid of the judicial exceptions created by the Alice-Mayo decisions. Getting rid of this uncertainty creates innovation because inventors and investors do not want to invest their money and invest their time into things that they do not believe they might not be able to get patented. So if you don't believe you can get a return on your investment, you're not going to be making those innovations that are key to our tech economy and to our technological supremacy. And so patents and having them be certain is key to make sure that those people will actually make those new innovations. So advantage 1 is competitiveness. So currently, the United States and China are in a race to see who can be the best technologically in innovation. This secures their place both economically and militarily in the global order, making them the global hegemon. Currently, the United States is the tech leader. We have the most technology, but China is beginning to surpass the United States in tech production and innovation, and is poised to become the global leader in technology, displacing the United States. So what this means is right now the US is ahead, China is catching up, and that will shift the global order towards China. I'll go into the solvency for this in a little bit, but you can already see on this card how it talks about how the Mayo-Alice framework created uncertainty which stopped our innovation. You can already see that we're already building the argument that it is patents that are key and that uncertainty really hurts our innovation. So first scenario is that Russia and China are revisionist powers. This means that they want to reshape the world to make themselves the strongest country and remove the US from that position. There's 2 things here. First, if Russia and China see the US falling behind in tech, they'll believe that there's an opportunity to attack. This does not require that the US actually falls behind in tech leadership. It just requires that the US be perceived to be falling behind. So even if we aren't falling behind, if there's a perception of it, that is enough to trigger the link. Obviously, if we did fall behind, that would also trigger the link, but it doesn't actually need that. This also means that the only way to prevent this war from happening would be for the US to maintain its tech leadership to prevent this kind of perception from happening. The other impact is totalitarianism. The argument made is that Chinese tech innovation drives global totalitarianism, like they are able to export their technology, which shows that authoritarianism is working and that the US is failing, so that other countries that are autocratic should become totalitarian completely, and that democratic countries will move towards totalitarianism. That's what the Belfield of 23 card talks about. The argument is that totalitarian states are far more irrational and likely to go to war than democratic ones. This is for multiple reasons, including that totalitarian states are more insulated and disregard actual information. So like if you're a dictator, you will get rid of people who say that you're wrong, which means that you will not be getting perfectly accurate information, which makes you more likely to miscalculate and fire like a missile, which could lead to greater escalation or even to the nuclear level. The way this is prevented is by the plan. Para would create certainty and predictability, which would make it where Russia and China war never happened because the US would not fall behind the tech race, because we would be incentivizing innovation through patents. Patents give investors a return on their investment and inventors a return on their time, which means that they will be more encouraged to go make those innovations if they can make money off it. The whole idea of the AF is that people make inventions when they can make profit, and that patents are key to allow them to make profit, and then not knowing if they will make profit is what's preventing them from making these high-tech breakthroughs. So, advantage 2, innovation. The uniqueness for this is that we are falling behind in innovation, as previously stated, but specifically because of subject matter eligibility, and that not having certain subject matter eligibility causes a shift to trade secrets, and trade secrets are a form of intellectual property protection that is not patent, trademarks, and or copyrights. For example, the Coca-Cola formula is trade secreted, it's not patented. So like you could make the actual like Coca-Cola formula yourself, but they don't have to release what it is. So like if somebody else were to figure it out, they could use the trade secret, but unless it is revealed in a legal way, the company gets to keep their trade secret forever. And it's protected by the fact that if somebody were to illegally share the trade secret, that is a massive crime. The argument is that trade secrets are worse for innovation because they do not disclose how the innovation is made, like patents do. So trade secrets, they don't tell you the formula for Coca-Cola, so you can't improve on the formula for Coca-Cola. All you can do is try to guess what the formula for Coca-Cola is and then maybe improve on that. But patents, if let's say the Coca-Cola formula were to be patented, which I don't think it can, but let's say it could be, people could look at that patent and go, I have a way to make this better, and thusly they could then improve upon that innovation. This creates follow-on innovation, which is key for a ton of things. Subject matter grounds are different than like getting rid of or invalidating patents on other things because it's saying that the entire subject matter itself can't be patented, not just the specific innovation, which means that entire industries will shift to trade secrets. So we outline a specific industry that this would be really bad for, and that's microbial innovation and the biotech industry. Currently, there's a lot of question on whether or not you can like patent genes, for example, and microbes. And the fact that there's uncertainty around that means that companies are just deciding to shelve and like hide how they make their like innovations, and that means that people are like sharing them, and there's no ability to create follow-on innovation. Further, it hurts specifically small inventors who typically look at those kinds of patents to try to make new technology, make disruptive technology. The fact that that's not being disclosed hurts them specifically more than anything else, which is bad because those disruptive innovations are usually created by small inventors who are more likely to make new things and better make on things than just like try to keep something in place. The argument is that microbial innovation also is necessary for environmental remediation, that these microbes can break down like plastics and papers in the environment through chemical reactions, and that in order to get this kind of like innovation, we need to have trade secrets not be protecting all these microbial innovations, and that it should be patented so that how it is done is disclosed and that other people can build upon it. This ties into the chemical pollution part, which is about how microbial innovation reduces chemical pollution, aka pesticides or pollutants can be broken down by microbes and can help stop the impact on the environment. So things like pesticides or toxic water runoff and get into our ecosystem, into our agricultural systems, which greatly risks like destroying them entirely, which creates like a risk of extinction. That's an IDEO 21 card. It's actually quite good. It's mainly talking about how like it's not highlighted here, but like 10,000 chemicals find their way into our food supply. So like these chemicals that microbial innovation would reduce from getting into our food supply destroy our ability to make food, and countries that do not have access to food are more likely to attack for it. And ecosystem collapse causes people to have to move around. It causes like insecurity. It causes people to go to war for resources because they're having to move away from where they were and for land, which all risk extinction in many different ways through escalation and or through not having resources that they need. The solvency is that by preventing trade secrets from occurring, by making them patent eligible, so like by making like microbial and biotech innovations patentable, it would be more predictable and that people would then use the patent system instead of the trade secret system, which would then allow companies to use that disclosed innovation to make new and better innovations. So instead of having to rely on trade secrets, they will instead disclose their inventions, and that will create much better innovation overall. Absent para-passing, the argument the AF wants to make is that companies will continue to switch to trade secrets, which will make it where people will not be able to innovate on innovations, which will prevent us from solving things like chemical pollution, and that chemical pollution will then destroy food production and the environment.
Next, we're going to be talking about the negative arguments on this topic, especially against para. So the three things that we're going to be focusing on today are the court clog disadvantage, the pathogen patents disadvantage, and the prizes counterplan. So first, the court clog disad. First, we'll talk about the uniqueness story. So the concept of court clog is how busy and overstretched the courts are. The most common metric for determining this is the caseload, so essentially what judges have on their docket for the day. So the argument that the neg wants to make when going for this disadvantage is that court clog is down. The main warrant for this would be smaller caseloads, so if you win that courts can manage everything they have now, their cases are enough, they're not overworking themselves, and they have enough resources to manage everything effectively, then that should be sufficient to win your uniqueness story. An important thing to note for uniqueness is that COVID/the quarantine caused a lot of court clog. There was a massive backlog because people had to stay home for a while, so things weren't getting done, especially in that initial 2 to 3 week period. Then it took a little bit of time for everything to get back to normal. I would say that at this point, we've mostly recovered from the COVID court clog situation, but there's definitely still some remnants, and it's not as low as it used to be. But the main argument that the neg should say against this is that the general trend is downward. So even though court clog is maybe not where we want it to be, or it could be a little better / smaller, it's still declining overall, and the AF would still reverse that trend. So the AF might also say in the 2AC or the 1IR maybe that specific types of litigation are up. So the most important thing that they'll probably say is some form of intellectual property litigation, usually about patents or trademarks, sometimes copyright, but I haven't seen as much of that. There are also specific neg cards in the novice packet to respond to these arguments specifically. I'm not going over all of them because they should be fairly self-explanatory, since most of them are more about statistics. Next is the link. So again, this is specific to para. The argument that the neg is making is that the AF causes more court clog, which then hurts solving the impact. So the argument is that the AF would increase the number of patents because it changes criteria, as discussed in the previous section, for what can and cannot be patented. That means there's more litigation, because if more people have patents, they're more likely to engage in lawsuits, since if they see someone recreating a product or an invention that correlates to the intellectual property protected by the patent, then they're probably going to sue that other individual, that other firm, for infringing on their IP right. The link can also turn the case. So what this means is that, especially in this context, it essentially hurts solvency for the affirmative. If court clog is high, that probably hurts the effectiveness of both the courts and the PTO, which, as we discussed, deals with a lot of these patent applications as well as the patents themselves. So the PTO reviews all applications, and if there are a bunch of patents coming in all at once because of this change in criteria, the chances that they review all of these in time or they review these effectively is fairly low. Additionally, a lot of patent cases come up in court, and judges are already not patent experts. There are a few judges that specialize in intellectual property litigation, but this isn't the majority, and a lot of judges hear patent cases when they aren't really qualified to do so. So if there's a lot of cases surrounding patents and judges have a lot of work on their plate, they're probably going to end up making worse decisions, which leads to worse quality patents and a lower bar for what is acceptable, which probably has some negative consequences for the solvency of the AF. The internal link, which is what gets us to the impact, is essentially that court clog prevents us from solving warming. So the argument that the neg is making is that a larger caseload trades off with prioritizing certain things. So obviously judges can only deal with a certain amount of things in a day, a week, a month, however long, but they obviously have to make choices between what they prioritize. If they're forced to deal with a bunch of patent cases, that means they're going to not have as much time to hear about trials about climate change and climate change regulations specifically. So these resources are not infinite, and they kind of trade off as time goes on. So if judges can't hear one case, then they're going to prioritize another one, which is the main internal link argument. The other part of the internal link is that courts are necessary to solve warming. So I pulled a line from the Carline 21 card, which I believe is in the 1NC shell in the novice packet, but it says that courts serve as the guardians and architects of law in the environmental context. Essentially, courts are responsible for interpreting the law, so that means interpreting regulations by government agencies, by Congress, some statutes of, whatever law has been passed, what it means for companies. Courts are able to fill in gaps that these environmental agencies and government officials cannot necessarily do because they have a lot of work to do. So courts are able to kind of guide the process of how that regulation is developed and actually applied in the real world, which is the main reason that they're necessary in the fight against climate change. Next is the impact. I'm going to spend a little bit of time on this just because warming is a very common impact in debate, and I think it's important for everyone to know about it. So I put in the impact card that's in the 1NC shell in the novice packet. I think it's pretty good. The main warrants for why global warming is existential. First is that the Earth is uninhabitable. Obviously, we are living under certain conditions as humans. If those conditions become changed by extreme heat, it probably means something bad for the ability of our species to survive. The main reasons that this would happen is because of the temperature, but also because crops would fail, since there's a lot of CO2 in the atmosphere, which causes agriculture to fail, or at least be diminished a lot, which means less people get fed. There are also compounding risks. Some cards call this cascading risks, but essentially it refers to the concept that some risks are brought on by climate change, even if they're not directly caused by the change in temperature. So some examples are rising sea levels and crop failures, which was mentioned above. So the main reason that those things are harmful is because they would force a lot of people to flee from their homes and migrate to other places, which puts pressure on certain societies. It also probably will cause some instability, so it could cause government collapse. That's an extreme example, but certainly if there's population pressures, then there's certainly going to be instability within the government and also within those cities where a lot of people are migrating. The other argument is conflict. So obviously, if there are fewer resources and especially less food, which was explained earlier, people are going to go to war. Certainly, if there are less resources, then we're going to have to kind of fight to share them, or at least some people will see it that way, which means it kind of acts as a filter for all of the war impacts that the affirmative will likely have. I put some warming terms to know. I'll go over them quickly. So first, non-linearity. This essentially refers to the idea that global warming will not happen in perhaps a linear pattern, but rather will increase in non-constant intervals. So, for example, we won't go 1 degree, 2 degrees, 3 degrees, 4 degrees. It might go up and down a little more inconsistently, which makes predictions difficult and increases the severity of these risks. The next argument is about feedback loops, which essentially refers to increases in the temperature that cause more effects of climate change to happen more rapidly. So the main example that you'll see in these cards is ice melting. Since if ice melts, then there's more water where sunlight can reflect off of that, which the sunlight from that then contributes to heating up the earth even more, which then leads to more ice melting, which then leads to more sunlight, more temperature extremity, which means it's a sort of loop. It's a cycle that makes itself worse as time goes on. The last thing is tipping points. These are essentially points in terms of the temperature where we can't go back. So a lot of scientists think this is 1.5 degrees Celsius or 2 degrees Celsius, but essentially once we get to the tipping point, we can't go back. So if scientists are right that it's 2 degrees, once we hit that point, we can't go back to 1.9 degrees. We're stuck at 2 degrees or below, which a lot of people and climate scientists will emphasize the importance of preventing us from even getting to that tipping point so that we can deal with reversing the risk rather than having to cope with a world that's already struggling. Next, the pathogen patents dissent. I believe this one is a little bit more self-explanatory. So the uniqueness story is the same as Aff uniqueness. Genetic sequences are currently not patentable under the Alice-Mayo framework and Section 101. The other part of the uniqueness story is that global cooperation is high, specifically in the context of innovation on things like disease. So the neg will say that this is a result of the limits on patentability. Since they're not patentable, everyone can freely use them. There's no exclusive right preventing other people from creating inventions based on these ideas, since they're not owned by any single person. Next, the link and internal link, which are fairly similar in this context. The argument is that Para makes it possible to patent genetic sequences. So this is something that would be a result of passing the Patent Eligibility Restoration Act because it changes the criteria for what is and isn't patentable. Genetic sequences right now are considered too abstract to be patented, but obviously changing their criteria for what is and isn't abstract would result in genetic sequences being part of a patentable invention or innovation. Once a person has a patent right or a firm has a patent right, other people or firms are not able to recreate that or replicate it or even potentially build on what has already been patented or developed because there's a right getting in the way of future innovation or new inventions to come. So this prevents cooperation between firms and also between countries. If there's a company in the US that has a patent, then a country like France will also not be able to innovate because the patent is binding, no matter where you are. So the argument is not just about cooperation and collaboration between firms, but also between countries and the global response to disease and disease threats. So the argument to the disease scenario is that this undermines our preparedness for pandemics. It would undermine our ability to create vaccines effectively because if other people are not collaborating and working with us to create effective solutions, then it'll be much harder for us to respond to these things in time, especially if only one person has the right to make an invention or an innovation that deals with this virus, which would fall under the genetic sequence that could be patented. The main argument I expect AFs will make against this is a link turn. So they might say that gene patents are key to vaccine development and innovation because they incentivize people to create innovative solutions. The best neg answers, I'll go over each of them quickly. So first, patent thickets. This refers to the ability of companies to get multiple patents which cover a very similar idea or a similar area. So this means that a company can get not just one patent on a genetic sequence, but also a patent on a similar genetic sequence or a similar virus that is kind of falling within the same area. They could also get a patent on technology needed to study and explore and build on that virus and create innovative solutions to it, such as vaccines. So this prevents follow-on innovation. Follow-on innovation is the idea of people building on what has already been made. So if I create a new vaccine, then follow-on innovation would be another firm or another individual creating a better vaccine or an improved version of it, or even some technology that helps distribute the vaccine or make it more effective. If there's patent thickets, it's very hard to access that since people cannot actually build on anything you've created since the exclusive rights cover almost that entire area. The next argument is about downstream innovation. So this is very similar to follow-on innovation. Currently, because there's no exclusive rights on what can and can't be patented, then other companies and inventors besides the person who would get a patent in the world of the AF, they're able to join in and collaborate on the process and create better inventions. This produces more effective solutions and innovations because when more people are working together with a diverse amount of perspectives, then people can come to better solutions and also facilitate innovation more quickly because there are more people working on it. The last argument is about affordability. So if patent holders have a monopoly on their invention because they have an exclusive right, they're able to charge whatever they want. If they don't have other competitors in the market, especially if they're able to get a patent thicket, then it doesn't matter what customers want to pay or other firms want to pay. They have to pay the price that the patent holder sets because they don't have another option. No one else is able or willing to supply it because there's an exclusive right granted to that firm or person. The argument that the neg should make, or as to why that matters, is because it prevents the distribution and accessibility of these vaccines and the study of these viruses. So if we can't effectively, discuss or build on these inventions by other companies because they're not affordable, or we can't license them, or we can't pay for these things that they're making because they're so expensive, then a lot of people will not end up getting access to care they need in times of crisis, which makes pandemics significantly worse. The impact, as referenced many times in this section, is pandemics. So the argument that the neg should make is sort of a brink claim. So COVID obviously happened in, a few years ago. It was pretty bad. Many, many people died, but the next pandemic will arguably be even worse. they're naturally becoming more lethal. COVID was already bad enough, and that was even a step up from some of the other pandemics that we've seen. And the concept of globalization and interconnectedness, which is just the idea that we're very close to each other, we're able to travel to other countries, we're able to transport ourselves and be connected with other cultures more easily, is that it allows those viruses to spread more quickly and more holistically because we're coming into contact with so many people. There's also the threat of engineered pathogens, which essentially refers to the idea of using biotechnology to splice viruses together. So an example that you'll see a lot of people, or not a lot of people, but a lot of authors of these cards reference is Ebola and smallpox. Smallpox is basically not a threat at this point in our society, but it was very, very contagious especially when it was a bigger thing. Ebola was less contagious, but it was significantly more lethal than smallpox. The argument that these authors are making then is that if someone acquired biotechnology and was able to make these two viruses that are one of which is lethal and one of which is contagious and combine them, then it could create almost a super virus that makes it impossible to respond to them effectively and kind of defeats the natural limitations on pandemics that already exist. You can also make the argument that this causes instability and nuclear war, which is the Suzuki card, also in the novice packet. Since there's societal instability brought about by diseases and pandemics, that increases the risk of nuclear war, which I think is better phrased as a turns case argument for the affirmative than an independent impact, because I don't think the card is amazing. The AF will probably say that COVID proves there's no extinction from disease, but all of the stuff we talked about engineered pathogens and future diseases, kind of answers this. Alright, the last argument we're going to be talking about is the prizes counterplan. If you're a novice, you might not be introduced to counterplans until slightly later in the season, but I think it's still important to talk about, especially for some of the older debaters, and it's important to get an introduction to this anyway, even if you're unfamiliar with it at this point. So, the counterplan I've pasted in the text. The United States federal government should establish an innovation prize system for novel, non-obvious inventions that are ineligible for patents. So, essentially what this counterplan mandates, or fiats, is that instead of creating a patent system or expanding patent eligibility as the AF would do in the context of Para, we create a prize system. So a patent is a legal exclusive right to intellectual property or an invention, as we've discussed. The difference between that and a prize or a prize system is that the prize does not actually grant a legal right. It is just a sum paid out by the government to inventors who create a certain thing. So this is an incentive, but it's not an exclusive thing. So Elon Musk created a prize system for carbon sequestration, which is a solution to climate change. He's offering $100 million to anyone who can demonstrate a carbon capture technique that sequesters X amount of carbon at a low cost. This is an example of what the prize system would do. So the government says, hey, we need this kind of invention. Then inventors, because they want money and they have a financial incentive to produce that good, since they know they'll be paid for it, they are going to try to innovate and solve that problem and work towards a specific end. The solvency argument is very similar to the net benefit argument, which sounds a little bit confusing, but it actually is fairly intuitive when you think about it. So the argument that the neg is making is that patents are bad. This is very specific to innovation, which is what matters most for the para-affirmative. If you win this argument against para, then it makes it very hard for them to get any offense or win anything against you, because the entire affirmative relies on the concept of innovation. So the argument that you should be making for solvency on this counterplan is not just that prizes solve innovation best, but that patents are bad for innovation, and any risk that prizes are even slightly better is a reason to prefer the counterplan, even if prizes are not the best solution to all innovation. So patents are worse for two main reasons. First, follow-on innovation. We discussed this a lot on the pathogen patents dissad, but this really applies to all innovation, especially in the context of patents. Patentees or patent holders have an exclusive right to use and recreate their invention, other people do not share that ability because the patent right blocks them from doing so. That means other people cannot join in on the process of innovation, which is what follow-on innovation is about. The other distinction between patents and prizes, which is described in this Tabarok card that I've put in the slideshow, is 0 to 1 innovation versus 1 to n innovation. So 0 to 1 innovation is the idea of creating something new. So, for example, if I create a totally new technology, never seen before, never developed before, I was the first person to think of it. That is 0 to 1 innovation because there was nothing, 0, before, and then I created something. Doesn't matter how good it is, that is the example of 0 to 1 innovation. 1 to n innovation, on the other hand, refers to the process of improving that initial invention. So I decide that my technology that I've created to solve some problem is unique, but it doesn't really work very well. So then the n refers to however many improvements are being made. That just is a fill-in for any number. The process of 1 to n improvement / innovation is making the initial technology better, which is only made possible by a prize system where everyone can participate and there's no legal exclusive right preventing other people from joining in on the process of collaboration and innovation. The net benefit, the main argument for this is that patents are bad. This is an internal link turn to the Aff, which is what we were describing with the stuff about para and innovation. If you win that patents are bad, regardless of what happens with the rest of the counterplan or whether or not prizes solve anything, that is an internal link turn to the Aff because it means that they can't actually solve any of the harms they've presented. If patents are bad for innovation, then all of their 1AC impacts almost become impacts for the neg, because if the Aff hurts the innovation that they're trying to bring about or maintain, then voting Aff for the plan, which is worse for innovation, means that the impact about innovation in the 1AC will inevitably come about, because if patents are bad, there's less innovation post-Aff than there is now, or than there is in the world of the counterplan. The last thing is concluding thoughts. So I'm sure all of you are kind of digesting this, and I'm sure you've already done your own research or at least read through a lot of these concepts to a certain degree. The question then becomes, how can you use your knowledge and maximize your success this year when it comes around to actually debating in round or doing your own research or making your own arguments? This topic is very hard. I am a senior. I've been doing debate since my freshman year, and even I am struggling. It's a very technical and legal topic. A lot of these concepts are not self-explanatory, especially the ones presented in the resolution, because they're very specific legal jargon, and they require a lot of knowledge, which most people do not possess. If you're having trouble wrapping your head around these things, don't worry, because I did too, and I still do to a certain extent. When Aff or neg teams look for new arguments, because that's likely what they'll do, especially in the later season, they'll probably be looking for very niche legal things, whether that means a court case, a legal controversy, or ambiguity, or a political process for, maybe the patent application system, or how trademarks are reviewed, or something like that. So what can you do in the face of this seemingly very difficult situation? So the main thing that I can emphasize is research and reading. You should try to understand these concepts early because it'll guarantee your success later on, since you can focus on thinking through a lot of these things and not having to comprehend the more basic concepts. I say basic in quotation marks because these are obviously very complicated, but in terms of what will likely be discussed by the end of the season, this will seem basic at the end. So if you understand these early, then it'll be much more helpful to you than if you have to play catch up later in the year. So the research and reading component, it can literally be Google searching, spending time looking through the news, looking through some scholarly articles about whatever's happening with the patent system right now, how copyrights are litigated in court or something. Just anything you need to do to fill yourself in on whatever legal controversies or legal aspects of the topic that you think you need to understand. Prep is going to be very hard. There is not a single generic on this topic, not a unifying one. My advice is that you should approach your prep in categories. I would focus on themes of AFs rather than specific AFs, like individual ones that were maybe cut at camp or you think will be cut later in the season. So one example is patent subject matter AFs. Para falls into this category, but a lot of AFs already do and will continue to deal with the idea of increasing what is and isn't patentable. This also applies to some of the other topic areas, but I think patents are the most intuitive because they can change the criteria for what can be patented, and a lot of teams will read advantages about innovation specifically based on that. The last thing that you can do is be confident. Debate is a communication activity, which means that if you believe your arguments and own them and act like you're winning at every round, you're significantly more likely to win. Evidence quality and just understanding the topic is incredibly important, but that's only half the battle. If you're not presenting your arguments effectively or confidently, then your chances of winning unfortunately decrease. If you need help at any point, the Empower Debate organization offers free resources and mentoring to help you succeed. So we're catalyzing our policy mentoring program, and we're also working towards a full resource creation program. This is sort of the beginning, but we're going to be posting a lot of resources and providing mentoring to anyone who needs it throughout the year. So if you're interested, definitely reach out, and we are all here to help. Thank you so much for listening. I hope you all have an amazing season, and good luck.